afternoon, Your Honour. My name is Jessica Daniel and I'm representing my client, the accused, Mr. Otto Lowtower, who has been charged with possession of more than 200 grams of MDMA pursuant to Section 9, subsection 1 of the Drug Misuse Act. Your Honour, today I am seeking a pre-trial ruling under Section 590 A, subsection 2E of the Criminal Code that all evidence found as a result of the vehicle stop by Senior Constable Tarjan be deemed inadmissible and excluded from trial. Today, I aim to show you that it is within the public interest to protect my client from the unlawful treatment of Senior Constable Tarjan in his unlawful disregard for the law when attaining the evidence. I will start by addressing the vest, followed by the vest and MDMA evidence, and then any oral testimony. Firstly, I would like to draw your attention to the principle established in Goldsmith and Sandyland that the evidence of the vest is only relevant if it can rationally affect the probability of an existence of the fact in issue, namely that my client had possession of drugs. Your Honour, there is no evidence to suggest that the vest belonged to my client. He denies he's a member of the Green Traders. He was not wearing the vest. The badge that relates to the term gun tower, though it sounds like low tower, it is still not my client's name. It could have belonged to anyone. It does not rationally relate to the possession of drugs. Therefore, I ask you to deem this evidence inadmissible. However, if you were to find the alternate, I then ask you to exercise your judicial public policy discretion as established in Ireland and affirmed in Bunning and Cross to exclude both the evidence of the vest and the MDMA. In doing so, I ask you to consider the following factors established in Bunning and Cross to inform your decision to exercise your public policy discretion. Firstly, Senior Constable Tarjan deliberately disregarded the law. He alleges he made the vehicle stop exercising his powers to do a license check under Section 60 of the Police Powers and Responsibilities Act. However, this is not a prescribed purpose of the Act. It is not unreasonable to expect a senior constable who is attached to a task force that specifically seeks to dismantle drug trafficking to know his powers that permit a vehicle stop. This is compounded by his failure to attain a warrant to search my client's vehicle. He did not consider the risk of searching the vehicle being illegal without a warrant. He simply assumed it would be okay under Section 60. However, any reasonable officer who had given it a second's thought would realise the obvious risk in searching my client's vehicle without a warrant. This speaks to his reckless and deliberate disregard for the law. Further, under Section 31, subsection 1A, Senior Constable Tarjan can only stop my client's vehicle if he reasonably suspects a prescribed circumstance under Section 32. A relevant prescribed circumstance may be Section 32, subsection 1C, unlawful drugs. Now, the Q-Light report that informed Tarjan of my client and Cole's alleged suspicious activities should not be reasonably interpreted that there could be drugs in the car. The report doesn't mention drugs, the vehicle, nor it was too broad. It could have been a recount of any activity. However, another purpose may be Section 32, subsection 2B, that my client was consorting with a recognised offender. This may be or speak to the vehicle direction to stop the car on the registration details or any other intelligence that he had acquired. So if you were to find that he did have reasonable suspicion to stop the vehicle, it would only give him power to stop the vehicle, and I submit he did not have power to search the vehicle, as per Section 31, subsection 1C, which only allows an officer to stop and search a vehicle if both the occupants and the vehicle are detained. There is nothing to suggest that he detained both the occupants in the car, nor did he detain the vehicle by ascertaining the keys and locking it. He simply just put it in park. Senior Constable Tarjan therefore had no powers under Section 60 or Section 31 to stop and search my client's vehicle. He simply ignored his powers under the PPRA and chose not to get a warrant. This is serious, as it is within the public interest to ensure that a highly experienced police officer would know how to lawfully obtain evidence against a major drug offence, a point which was highlighted by Justices Stephen and Akin in Bunning and Cross. Thus, I ask you to agree that Senior Constable Tarjan had a deliberate and reckless disregard for the law. Now, Your Honour, if you were to agree, you need only consider the cogency of the evidence if it is vital to a conviction and is of perishable nature. The MDMA evidence is vital to the Crown's case. However, there is nothing to suggest it was of a perishable nature or an imminent threat of being destroyed. Specifically, I would like to draw your attention to Section 160, which requires Tarjan to have reasonably suspected the evidence may be concealed or destroyed unless the vehicle was immediately entered and searched. Your Honour, Tarjan had already got my client to put the vehicle in park. He didn't put them in handcuffs or detain them, as he may not have thought it was necessary, as he believed he kind of had the situation under control, that no one was at risk of fleeing or that the evidence wasn't at risk of being destroyed. If you were to agree, Your Honour, this means that he had no reasonable basis to stop and to enter and search the vehicle, and by extension that the evidence was not of a perishable nature. However, if you were to find the alternate, that does not negate the fact that he didn't apply for a post-search warrant approval under section 161, which is both required and he would know this is an available option for him. This speaks to him cutting corners and deliberately disregarding the law. Further, it would have been easy for Senior Constable Tarjan to comply with the PPRA and attain a warrant and to get the evidence lawfully without substantial delay or inconvenience. He had already got my client to put the vehicle in park. It wouldn't have been much of a further step to detain my client, Mr. Cold, and then grab the keys and lock the car and wait a few hours for a warrant to be issued based on the evidence that he alleges he acted upon. The ease of which he could have lawfully secured this evidence is a factor I ask you to strongly consider in excluding the evidence, as observed by Justice Henry in R and Toon and Justice Applegrath in R and P and North. Finally, I ask you to consider the purpose of the PPRA, specifically Section 5E, which is to protect my client from the exact arbitrary use of power by Senior Constable Tarjan when he did not get a warrant to search the vehicle. Therefore, Your Honour, I implore you to carefully consider these factors and exercise your discretion to exclude the evidence under the public policy discretion. Finally, I ask that any oral testimony that Tarjan may submit the interaction between him and my client in the vehicle stop be excluded. His nervous demeanour may have been for a multitude of reasons. He was afraid to communicate to the police. He was afraid of police or scared of being caught up in someone else's wrongdoing. It is not relevant and should not be rationally extended as relating to the possession of drugs. Therefore, I ask for the testimony to be excluded. Convicting my client of this crime is a price too high to pay when considering Tarjan's blatant disregard for the law in getting the evidence. It is in the public interest to ensure that those who enforce the law abide by it. Therefore, I ask all the evidence to be excluded. Thank you, Your Honour, and that concludes the submissions.